In this video, we're going to look at the fundamental principles of the UK Constitution. And there are generally three main principles of the UK Constitution that we're going to look at in this video specifically. We're going to look at the rule of law, we're going to look at the separation of powers, and we're going to look at the principle of parliamentary sovereignty. Let's start with the rule of law. The most basic understanding of the rule of law means that it is desirable to be governed by rules. Okay? So a government of laws, not men, is the quoted phrase by Aristotle. The rule of law does, however, have many different interpretations. So the rule of law has a very basic understanding that it is desirable to be governed by rules. And so with that, we can take that and look at the many different interpretations that the rule of law has. So in England, the notion of the rule of law is claimed to go back to the Anglo-Saxon notion of a contract between the ruler and the ruled under obedience to the king. So the English version stresses the common law as law made by independent courts. So when we looked in the last video as the sources of the Constitution, what the common law was, and the idea that the common law has developed over thousands of years and in fact dates back to Roman law jurisprudence. According to Koch, the rule of law protected both ruler and subject, the ruler against criticism and then the subject against tyranny. But there are different interpretations of the rule of law. We have the core rule of law model. This is the basic idea of the rule of law in general. It means that government by law inform on general rules as opposed to it being the discretion of the ruler. We can then look at what we call the amplified rule of law, which claims that certain principles relating to fairness and justice are inherent in the notion of law itself. And then there's the ambitious side of the rule of law, which is what we call the extended rule of law. This is seen as the most ambitious version, and it claims that the law encapsulates overreaching political values of the community. There is also a distinction to be made between what we call a formal and substantive version of the rule of law. So the formal version of the rule of law centers on the shape and application of the law. It looks at how the law is shaped and applied to different cases. And the substantive versions look at what the law actually says, the content of the law specifically. Okay? Now we've looked at that, let's have a look at the idea of the separation of powers, which is the second principle we're going to look at today. The doctrine of the separation of powers basically just means that government should be divided separately across different branches, okay? This is most commonly seen as three branches: the legislative, the executive, and the judiciary. Now, each would have its own distinctive personnel and process, and each branch of government should be checked by the other two so that no one dominates the others. Okay, and in this country we have a legislative branch that is Parliament, which is centered around Westminster. We have an executive branch, which is the government, which is centered around Downing Street, and then we have a judiciary, which is the higher judiciary is centered at the Supreme Court. Okay. What about other versions of the separation of powers? Well, there's the famous French political philosopher Montesquieu's version of the separation of powers, which states that each branch of government is complemented by the idea of what we call a mixed constitution, in which different class interests check and balance each other. And this is particularly the case in the legislature. So we can look at this from a perspective of modern day UK constitutionalism, which is the idea that a mixed constitution can be found in the institutions of the monarchy and the House of Lords. However, the idea of a mixed constitution in today's society is cut off from its historical association with hereditary aristocracy, but might still be valuable as providing a check over crude majoritarian democracy. So the idea of Montesquieu's separation of powers is not just a separation of powers between the three branches, but also a separation of powers vertically among the different class struggles, okay? So the question of judicial independence can also be regarded as an aspect of the problem of separating powers, but it could also be described as an issue in its own right. Judicial independence is a principle that is safeguarded by the right to a fair and free trial under the European Convention of Human Rights, and we look a little bit more of the ECHR in the next video. A huge part of the separation of powers, the principle that each power should be separated, is the idea of checks and balances. And the separation of powers comprises the separation of function, institution, and personnel, including in the notion of checks and balances. The particular blend in any given case depends on the preoccupations of the particular country. So, for example, in the USA, they have a very clear and strong system of checks and balances. And there's little agreement among writers as to whether the idea of a separation of powers is valuable in the UK, and in what sense it even applies to the UK. And it also should be made clear that there is no distinct separation of personnel between the executive and the legislature. This is what we call a fusion of powers. And we have a fusion of powers in that the government sits in Parliament. So the executive sits in the legislature. Those two parts are fused. So they are not two distinct, separate entities. There have also been improvements to try and attempt to create further separation of powers in the UK. The most significant of which is the Constitutional Reform Act of 2005, which attempted to strengthen the separation of powers by creating a Supreme Court to replace the Appellate Committee of the House of Lords. So before 2005, we had the law lords sitting in the House of Lords, and they were the supreme and the highest legal judicial authority in the UK. But since 2005, since 2009, when this act came into fruition, the Supreme Court has now separated from Parliament. This thus injects an independent element into the judicial appointments, and it also removes the Lord Chancellor's role, which was head of the judiciary and Speaker of the House of Lords. So the Lord Chancellor was also a member of both the legislature and the judiciary. And now, since the 2005 Constitutional Reform Act, we see that split apart. The final principle is the principle of parliamentary sovereignty. The doctrine of parliamentary sovereignty provides the fundamental legal premise of the UK Constitution. The doctrine means that an act of Parliament must be obeyed by the courts, that later acts prevail over earlier ones, and that rules made by external bodies cannot override acts of Parliament. Effectively, that Parliament is supreme. It's the supreme legal making authority in the UK. And it does not follow, however, that the Parliament is politically sovereign. Because there is a distinction, although a fine line, there is a distinction between legal and political sovereignty. So the foundations of parliamentary sovereignty are relatively frail, and this is because we do not have a codified constitution that outlines this principle clearly. What we have instead is the idea of the 1688 revolution, which is where we see the transition between the power of Parliament and the power of the monarchy. We see the transition from power from the monarchy to Parliament. It is possible to maintain that the common law is really the supreme law-making authority, because it dates back before Parliament and it rests on fundamental principles that dates back to the ancient Rome. However, if we were to derive an ultimate source of sovereignty in the UK, we'd have to really find public acceptance of one or the other, okay? And it's generally the accepted practice that Parliament is sovereign. So the doctrine technically has two separate aspects. The first being that courts must obey acts of Parliament in preference to any other kind of legal authority. effectively meaning that the courts must follow the laws that Parliament has made. The second relates to Parliament itself, that no body, including Parliament, can place legal limits upon the freedom of action of a future Parliament. Effectively, the current Parliament that we have now, although prorogued, couldn't pass a law that binds a successive Parliament. Every single successive Parliament can create laws that outdate the ones from a previous Parliament, effectively. So there have been attacks on parliamentary sovereignty. There are a number of theoretical restrictions of parliamentary sovereignty, and this really draws into the idea of political sovereignty versus legal sovereignty. First of all, legal sovereignty has been challenged from the fact that we have the EU and EU law binding on the UK, and this is regardless of parliamentary sovereignty. Okay? So EU law is binding in the UK, and Parliament doesn't really get a say in whether or not this is the case. However, we do have sovereignty in the fact that the UK has voted for 95% of all EU laws that have been passed in the UK. So, despite the fact that our Parliament isn't binding, our elected representatives to the European Parliament and also representatives in the Commission and the Council of the European Union also make it very clear that they have a say in European Union law. Okay? Now, if we have a look at what we would call the distinction between illegal sovereignty and political sovereignty, the Human Rights Act is an example of political sovereignty versus legal sovereignty, because it could technically place restrictions on Parliament. These are not legal restrictions. Parliament has any right to remove and revoke the Human Rights Act whenever it wants to. However, this would be politically dire for the current Parliament, because the electorate wouldn't support such a move to remove the Human Rights Act from legislation. So it really does suggest that although Parliament is legally sovereign, the idea of it being politically sovereign is still shaky in terms of how secure that must be.